So we'll go ahead and get started. I know there's a few people in the back just signing in, but I'm going to go ahead and get started. My name is Linda Klein. I am the manager of the Sherry and Les Biller Patient and Family Resource Center here at City of Hope. How many of you have heard of the Resource Center or have visited the Resource Center? Oh, good. So a handful of you. So just so you know, the Biller Resource Center is located here on City of Hope campus, right by the main entrance. It is open to not only City of Hope patients and their loved ones, but to anyone who is interested or needs to learn about education, information related to cancer or diabetes. We have all kinds of free classes for the community, for patients, including yoga, music and art therapy, education on chemo, nutrition, and so forth. So if you ever have any questions related to diagnosis of a loved one, even if you're not a City of Hope patient, we encourage you to come visit the center. We're here to offer support, education, information any way that we can. So, just a few housekeeping items. Tonight, our Ask the Experts, as you know, is cancer and the law. We ask that you please put your cell phones and pagers on vibrate out of courtesy to those around you and to our speaker. If you need to use the restroom, it's right through those back doors. You go through the double doors behind you and you make a right. Just a reminder that City of Hope is a non-smoking campus. And we would appreciate, again, as a courtesy to our speaker, if you can please hold your questions till the end. We will have ample time for questions. And if you have a question as she's speaking, we encourage you to write them down on the index card that you have, and we'll be coming around to collect them throughout the presentation. We also ask if you could just please take a moment at the end of the presentation to complete the evaluation form. We really do pore over your comments so that we can make sure we're offering the kinds of programs and educational series that you are most interested in. So we do appreciate your feedback. And finally, I'd like to thank Becky Andrews and our marketing team, our web marketing team, and ITS for all of their assistance and support tonight. And just so you know, this event is being filmed, it's being streamed live, and it will also be available on the City of Hope website and on YouTube shortly. So, welcome to tonight's Ask the Experts, which is presented in collaboration with the Cancer Legal Resource Center. We are so incredibly fortunate to have with us today the director of the Cancer Legal Resource Center, Jen Fiore. The Cancer Legal Resource Center is a joint project of the Disability Rights Law Center and Loyola Law School Los Angeles. Prior to joining the CLRC, Jen was the supervising attorney of the Health Consumer Center at Neighborhood Legal Services of Los Angeles County, where she supervised the center's consumer assistance hotlines and the legal work of 3 medical legal community partnerships. Jen started her legal career as an advocate at the Western Center on Law and Poverty, specializing in medical debt and preserving public benefits for low-income Californians. Jen has also worked as an immigration attorney in London and taught writing in community colleges. She's a graduate of the USC Gould School of Law and holds an MA in comparative literature from Penn State and a BA in English and Spanish from Chapman University in her hometown of Orange, California. And on behalf of the Sherry and Les Biller Patient and Family Resource Center, I want to thank Jen and the CLRC. We see firsthand every day how patients benefit from their incredible resources, their expertise, and their guidance. The Cancer Legal Resource Center is truly one of a kind. There is no other legal resource center like it in the country. They serve patients and their loved ones all over the country. So with that, I would like to welcome, and please join me in welcoming Jen Fiore.
It's okay.
Sorry. I'm so sorry. It's Flory. I can't read. I apologize. Okay, thank you.
It's quite all right. Okay, I think I'm on here. All right, welcome, and thanks for coming to this presentation. I'm going to tell you a little bit about, first I'll tell you a little bit about the services of our center. We have our contact information on there, so should something come up and you need to contact us, you know how. Then I'm going to start going through just kind of issue spotting, some of the various legal issues that come up with a cancer diagnosis. We're going to cover some of the basics around health insurance issues, and then after that, some employment issues and a couple of disability insurance issues. But with all of these areas, there is a myriad of other things that could come up. So if you have general questions like how's health reform going to affect this, or I've heard of this other program, feel free to write those down. But if you have something really personal about your individual situation, I'd be happy to stay after and talk to you about that afterwards, or we can have you call our hotline. So moving on. The mission of the Cancer Legal Resource Center is to provide information and resources on cancer-related legal issues to patients, survivors, caregivers, healthcare professionals, employers, and others coping with cancer. Most of the people who call us are survivors themselves, but we do get a lot of calls from caregivers and then often from healthcare professionals who are helping somebody out with this situation. The CLRC is actually, we're celebrating our 15th anniversary this year. It started out as a tiny little program at Loyola Law School, Los Angeles, which was basically one attorney kind of in a closet on campus. It's now grown to, we have 6 attorneys and a couple of admin staff. But as we grew, we realized we needed a little more support, so we were essentially adopted by the Disability Rights Legal Center, so that way we have some help with technical assistance, with an administrator, and some other things. All of our services are confidential. We offer services in English and Spanish. If there are languages that we don't have on staff, we also have a language line. And ours is an educational model, meaning we're not the people that necessarily are going to sue someone or go after someone, but we can give you resources that might enable you to resolve your own problem. And if there's a problem beyond what you can resolve, then we can give you a referral. All of our services are free, so don't hesitate to call if you do have a question. And we do quite a lot of outreach around the country because we are a national program. Right now, we're averaging about 400 calls a month, and we do conferences and seminars all over the country. We do have an upcoming conference in Houston in March, but since that'll probably be too far for most of you, you would probably be more interested in our Los Angeles conference, which it's tentatively planned for June 28th, but until the ink is dry on the contract, we can't actually, get out of date. But if you get onto our mailing list or call us or something, we can get that to you. We offer teleconferences and webinars. There's some brochures in the back that have, we only have, I think, 2 more webinars coming up in the end of 2012, but there'll be a whole new series coming up in 2013. And we're working on getting the rest of our webinar materials posted onto our website. But in addition, we also have, at the website there, cancerlegalresourcecenter.org, we have a lot of issue briefs, or we're starting to get some self-help material on there, and we have manuals that are on different areas of law. So you can also contact us either on the phone, there's an online form, or you can even send us a letter if that's how you wanted to do it. Like I mentioned before, several materials online. We have a legal resource guide for people with cancer in California. Specifically, there's a healthcare professionals manual that we try to get into the hands of people who are helping people with cancer, and the other materials that I mentioned. Last year, we assisted over 4,500 people, and we're looking like we'll break 5,000 this year. So there are a lot of people that have been calling. Now, some of that, I think, is also indicative of the fact that there have been a contraction of a lot of free legal services because of the economy, but we're happy to help, so give us a call. The other thing that we have, I mentioned that we do referrals. We maintain a professional panel. So this is mostly employment attorneys, Social Security attorneys, different people who can help out if there's a situation where it looks more like litigation is really going to be the answer rather than just calling a government agency or dealing with your employer directly. And we have a professional panel. California is where we have the most professionals, particularly in this area, but we do try to get professionals all over the country since that's where our calls come from. Now, people always ask, what are cancer-related legal issues? Or sometimes when we refer to it as cancer rights, the question I get is, cancer has rights? No, not so much, but people with cancer have rights. So the big issues that we deal with most are the ones in red. That's health insurance, employment, and disability insurance. But we also get a smattering of quite a number of other issues, whether that be other government benefits, whether that be landlord-tenant law, family law issues, estate planning, We have an attorney who specializes in some of the genetic discrimination issues. So we do cover quite a lot of issues. And then just general consumer law, like dealing with debt. So let's get on to our subsets. We're going to start with some of the healthcare issues. So we like to start with some vignettes of people to kind of personalize what we're actually talking about. So here we have Sima. Imagine Sima. She's a young woman, probably about 28 or 29. She's a cancer survivor. She was recently laid off from work, and she previously had health insurance for her family through her employer. Now, because she's a cancer survivor, she has been labeled as somebody with a pre-existing condition. So she's going to have a hard time just, once she loses her employer coverage. So what are some of her options? Well, the first thing is COBRA, and that is whenever you leave your job, whether it be your choice, somebody else's choice, if you had employer coverage through your job, your employer is required to give you some notification. So that you can pay your own premium and keep that for 18 to 36 months. Now, a lot of people ask me, well, when I had my job before, I had a choice of a couple different kinds of insurance coverage. I could have gotten the HMO or the PPO, and I chose what I chose. Can I change my mind now that I'm paying for it all? Unfortunately, the answer is no. And so the real trick for COBRA is that usually once you don't have a job, it can be very difficult to pay the premiums. So usually what we advise people is if you have any access to any sort of financial assistance, sometimes that be specific charitable organizations that specialize actually in helping people to pay their insurance premiums, then that should be something that you would prioritize. For a lot of assistance groups, it is effective for them to pay somebody's insurance premium rather than try to pay their hospital bill because obviously the premium is much smaller. But that is, the reality that a lot of people face. When they lose their job, they have opportunity to keep their insurance, but keeping that insurance comes at a cost that they often can't afford. So some of the specifics about COBRA is that in order to be eligible, there have to be at least 20 people in your group or at your place of employment. Now, in California, it says, remember here to check state law, we have a program called CalCOBRA. And that does allow for groups of 2 to 19 employees to be covered under it, but it's a slightly different program. So how do you get COBRA? You have to have a qualifying event. And this could be your termination of employment. And your termination of employment, it can also come in kind of a slightly different variation where if you were on medical leave and you ran out of your medical leave, that could also be a qualifying event. The other common issue is when the primary person leaves the plan. We see this a lot when there's a couple and the person they got their insurance through becomes eligible for Medicare, so they're no longer in the employer plan. This would protect that other partner for an additional 3 years. Or the other thing that we see is when children age out. Currently, children are allowed to stay on their parents' plan and until age 26. That was a recent change in the law as a result of health reform. So it's not even so much children anymore as young adults. So it feels a little funny to call them children. But they can stay on their parents' plans until age 26. And then at that point, they actually get this extra 3 years where if the premium is, if their parents or they pay their premium, they can still be part of that group coverage plan. So that actually extends their coverage until 29. So CalCOBRA, like I said earlier, it applies to employers with 2 to 19 employees. So pretty much if you're an employee, usually you fit this. And it lasts for 18 months. The other thing that it does is when you combine it with your regular COBRA, you could take the first 18 months of the federal program and then you go 18 months in the state program. So that allows for a total of 36 months. Now people ask, because you can sign up for CalCOBRA, the 18 months there is only when you're adding it on to the federal. Some people ask, why wouldn't you just sign up for CalCOBRA immediately to get it the full 36 months? Well, it's a little higher cost. Instead of paying 102% of your premium, with just 2% being for the administrative cost of keeping you on, at the state plan, it's 110% of the premium. So it's the whole premium, not just that you pay, but that your employer had paid for you before. Now, moving on, if Sima decides that she can't afford the COBRA, If she has children, for example, and she's unemployed and she qualifies for Medicaid, she has a couple different options there. So Medicaid is the state, or is the federal program. In California, we call it Medi-Cal. That is for certain people with very low income, but they also have to have something that qualifies them for Medi-Cal. So that has to be that they have a disability as is defined by the federal government, and it's a pretty high standard for that definition. We'll get to that towards the end. Or they have to have children that are dependent on them, and there's either only one parent in the house or the parents are facing unemployment. Or they have to be pregnant. You know, there's very limited people who actually qualify for Medicaid in that sense, or over 65. So if she qualifies for that, she could also, in California, there's the option where if you have the option to take an insurance program like COBRA in this sense, sometimes the state, they'll do an actuarial analysis and they'll decide, would it be better for the state if we just paid her COBRA premium, or would it be better for the state to enroll her in Medicaid? In most cases, it would be cheaper for the state to just pay her premium rather than pick up all of her health care costs. So a lot of times HIPP is another program that we like to refer people to, because essentially to the person getting it, they're still getting their same insurance that they got before, only now somebody else is paying the premium. Okay, a couple other things. You know, what happens when COBRA is no longer available, or you've used all that up? Are there any other protections that are out there? Or what happens if you're switching from one kind of coverage to another? One of the things is the Health Insurance Portability and Accountability Act. Usually when people hear HIPAA, if they've worked in a medical setting at all, they think of it as privacy laws. That is also part of HIPAA. But the part that we're concerned with today is the part that allowed people to transfer from one insurance to another without being dinged for having a pre-existing medical condition. Now, there's a couple complications to HIPAA, which is why they ended up going a little further with health reform laws, because it only covers certain people. So it covers people going from group plan to group plan. It covers people going from a group plan to a HIPAA individual plan, which is a very specific type of plan. And the idea is that you can't have any break in coverage of your health insurance for 63 days. The HIPAA law only protects people who had previous coverage, because the idea behind it was these people had already been taking care of their health care needs. Now, we know that most people who are uninsured are uninsured because they can't afford to get insurance any other way, and it's not that they've chose to just let their health go. But that is the fact of the law, that it's only protecting people who already had health insurance. The way that it does protect them, though, is by giving them a right to an individual plan. So when you run out of your group coverage, you are guaranteed to be issued an individual plan. It limits the pre-existing condition exclusion period, so they can't just look back at your entire life. Or if you had those pre-existing conditions already covered by insurance, they can't exclude them. And then it gives you credit for previous health insurance coverage, which is another way of saying the same thing. Explain a little bit how that works in a second. So first of all, in order to be eligible for it, you can't have COBRA or state COBRA that you're still eligible for. And when I tell you a little bit about the premiums, you'll understand why you wouldn't even want to. You have to be ineligible for other group plans. So if you went to an employer and they offered a group plan and you weren't too excited about it, you would need to be, you would need to take that rather than apply for a HIPAA plan. And you can't have a gap in coverage longer than 63 days. So before we go on, the way that this works out is generally if somebody's COBRA runs out, they're thinking, okay, I need some sort of plan now, and they have a couple of options. What they can do is they can take that plan that they were on, which is still technically a group plan, and they will convert it into an individual plan. Now, there's a couple different ways you can do this in California. In California, they have to notify you of your right to a conversion plan, which means essentially what it sounds like. I had a group plan. I paid for it through the COBRA program. Now I'm going to have an individual plan, and it would be through the same insurance company. If you weren't happy with your insurance company, in California, you can also go to other insurance companies and ask them for their HIPAA plans. The issue here, though, is if you have a pre-existing condition, a lot of times when people call the other insurance companies, they'll say, I'm sorry, you don't qualify. you need to actually use the magic words and say, I need a HIPAA plan, because it's often an entirely different part of the insurance company that's dealing with those plans, and the regular agents on the phone don't always know that HIPAA plans even exist. Now, once you've converted from whatever your entire employer premium was, which can be anywhere from $200 to $700 a month, you move into the HIPAA plans, which are plans that are state regulated, and they generally are in the $700 to $800 a month range. So these are extremely expensive plans because they're plans that are designed specifically for people with pre-existing conditions. So they've already done the actuarial analysis of how much people will pay, or how much they will cost, and they found that the cost is going to be rather high. So HIPAA plans can be rather expensive, but there are a couple other things that you can do. So the first thing would be the state high-risk insurance pool. In California, we've long had a program called MRMIP, which is the Major Risk Medical Insurance Program, and that's a program that is, it's run through the state of California, and it's basically you go into a pool that's all people who have either been denied insurance or been charged an extremely high rate because of their pre-existing conditions. And the general rule of thumb is if what you're being offered is something that costs more than the major risk medical insurance pool, you can probably join the major risk medical insurance pool. Right now, the rates for it range from the absolute cheapest is $281 a month for a Kaiser plan for people who are, under 18. The most expensive goes all the way to $2,000 a month, and that's more like a PPO plan through, I believe, HealthNet, Anthem Blue Cross. But you do have a couple different options there. Generally, Kaiser is the cheaper option, and they've just announced that in 2013 they're actually going to pull the premiums down, I think for the first time almost ever. So it used to be that this was the only high-risk insurance pool that existed in California. So until recently, there was actually a waiting list to get into the pool. I'll talk in a minute about the other pool that we have, and the fact that we have this other pool and the fact that we have extended to what age children can stay on their parents' policies has meant that there have been fewer people applying for this, so there's no longer a waiting period. So what happens is the month that you apply, if you apply before the 15th of the month, you get your insurance the very next month. If you apply after the 15th, you have to wait an additional month, and then you'll be enrolled in either the Kaiser or the Anthem Blue Cross. The other program came apart as part of the federal health reform. They set up a stopgap program before the rest of healthcare reform occurs in 2014, and that stopgap program is called the Pre-Existing Condition Insurance Plan. This plan is one that you can enroll. The blue down there, that is our federal website for it, but it's run by the state here in California, so you could just go directly to pcip.ca.gov, and you'll get information both about this program and about the MRMIP program. Now the one trick about this program is that it's only for people who have been uninsured for at least 6 months. The idea was there's a whole bunch of people who've been trying to get insurance and they've either been denied or they've been quoted at rates that are way too high, so we're going to set up a program for them. Well, it's kind of put us in a strange situation because right now the premiums on that range from $119 a month to $535 a month. So obviously there are a lot of people out there who have pre-existing conditions and are insured who are saying, wait a minute, this is more expensive than what I'm paying. Can I get into the PCIP program? Unfortunately, right now, the answer is no. So MRMIP is the other program that you would have the option. So if you were willing to take Kaiser or something like that, you might be able to bring your insurance premiums down. But, or if the Anthem Blue Cross, when they finally do lower the rates in 2013, that might work out. Most people at City of Hope don't want to take the Kaiser option because that comes with going to Kaiser. But the PCIP program, if you know that people have been without insurance, and that means without creditable coverage. So if you had a policy that was just a catastrophic policy that would really only cover you if you were going, if you had a big emergency or something like that, that's not really creditable coverage. So then you might qualify for this program. This program is set to end in 2014 because that's when they're going to set up the health insurance exchange, and that's also when they're going to stop being allowed to deny people or charge people more for pre-existing conditions. It's still a little bit up in the air what those final plans will look like and how much they will cost, but that's the idea down the road. Okay, and like I just mentioned, starting in 2014, the only things that they will be able to consider will be whether or not you smoke, how old you are, and where you live. And those will be the only things that they can use to determine how much you will pay for your coverage. Obviously, they can determine if you're buying, the Cadillac plan versus the bare bones plan, but otherwise they can't take into consideration personal factors such as your gender, your genetic history, your medical history, your health status, or anything else that might have been labeled a pre-existing condition. So for most people who have had a cancer diagnosis in the past, this is something that will make insurance accessible to a lot of people, but like I said before, we still don't know exactly what those rates are going to look like. Okay, so Sima's plan, now that she's had all this laid out for her, first of all, she wants to check that her employer notified her and that she was offered COBRA. Employers have up to a month after you lost your insurance, or up to 15 days after you lost your insurance, to notify you that you have the option to take COBRA, and then you have about 2 months to decide whether or not you want to take COBRA. If something happens in that 2 months, you can go back and pay the premium for it and still get it covered. So in her case, she's probably going to elect COBRA, and then she's going to need to figure out how she's going to fix her finances so she can cover that and prioritize that over some other things. So now if she were just a couple years younger, she might have tried to get back onto her parents' plan, because one of the interesting things about the new law that requires insurance companies to allow parents to keep their children on until age 26, it does not matter if those children are married, it doesn't matter if they have kids, it doesn't matter if they don't live with the parents, it doesn't matter if they're in school, it's just the bright line with the age there. The only thing that matters is if you have an option to get employer coverage through your own job, and that'll end in 2014 where they won't even look at that anymore. Okay, so our next person is Jane. Jane recently graduated from college. She's been working part-time at a law office for 2 months. She doesn't have health insurance through her employer because she only works part-time. She had student health insurance while at school because, like many schools, her school required her to have their health insurance if she didn't have it. Or she could have been on her parents' plan, but she aged out of her parents' policy when she graduated. Now, 2 weeks ago, she was diagnosed with cancer. Last week, she told her supervisor that she had been diagnosed and she's going to need some flexibility to get treatment. Jane's not exactly sure what her rights are vis-a-vis her employment, so we're going to go through what some of those might be. Now, the two major areas that we're looking at workplace protections are going to be the Americans with Disabilities Act and state laws that kind of follow that. A lot of times when we talk to our callers and we mention the American with Disabilities Act, they tell us rather adamantly, I have cancer, I don't have a disability. And that may very well be true, but also the Act has certain provisions that protect people who have a chronic disease or something that might mean that they need a certain type of accommodation at work. So don't get hung up on the terminology, look at the rights that it protects. Okay, so the ADA does apply to employers with 15 or more employees. And it does cover some employees that have a disability as defined by the law and are qualified. Now, the law defines qualified as people who can perform the essential functions of the job with or without an accommodation. So if you can't do the job regardless of your health situation, you're not a qualified employee. The definition of disability can be a little complicated, so we're going to go through definitions. Okay, so the first one, you have to have some sort of physical or mental impairment. Now, sometimes people are thinking, why are we talking about mental impairments? This is a physical condition, cancer, but one of the things that comes up quite a lot is actually chemo brain, or just having, a situation from your treatment that is making it more difficult for you to focus or concentrate. You might be protected under the Americans with Disabilities Act. Now, that impairment has to substantially limit a major life activity. Now, until recently, it was really complicated. What is a major life activity? Some of the things that are definitely major life activities are things such as walking, talking, breathing, eating, caring for oneself, activities of daily living, reproduction, working maybe. But what happened is a few years ago, there were some amendments passed to the ADA Act that further broadened what a major life activity was and what a substantial limitation were, so that in many cases, if it is a condition like cancer, it is something that's going to qualify. Okay, so you have to have some sort of substantial limitation, something that's actually making it difficult to perform that major life activity. So they do look at what the nature of that impairment is and the severity. They look at how long it's expected to last. It used to be very difficult for people with cancer to qualify under this because they looked at it as something that was either going to be cured or it was going to end your life. So clearly it's not a disability. Fortunately, they changed their mind on that. And this was done through legislation that was signed by George Bush. So it was, you know, it's something where the court started going one way and the Congress and the president decided, no, that's not what we want to see. Now, they do also look at the impact of the disability. Occasionally, for example, for people who wear eyeglasses, they say, well, what you have to correct that is enough that you're not really disabled. But in almost any other area, they're not going to look at how it's corrected. So for example, cancer, there's often treatment for it. But the fact that there's treatment for it does not mean that it is not affecting you. It is not limiting major life activities. And in fact, it is often the treatment that is the problem itself. Okay, now it doesn't just protect people who have a current disability. It also protects people who have a history of disability. So if you are applying for a job and you know your employer is wondering if you've ever had cancer because they're trying to figure out how much they're going to have to raise their insurance rates, ADA protects you. They're not allowed to ask things like that. It also, in terms of regarded as having a disability, there have been certain cases where, you know, whether it's because of rapid weight loss or other things, that somebody's assumed that somebody has had cancer who hasn't had cancer. And if you're regarded as having a disability and you don't have a disability, there's still certain protections that you have. And then in very limited cases, it does protect the caregivers. Occasionally, parents who are taking care of children with cancer can face a certain amount of discrimination because people don't want to hire them thinking that they won't be very hard workers. Okay, so reasonable accommodations. Sometimes people are a little concerned that the definition of disability under the ADA is too broad. But this is the other half of it. The employer only has to do something that's reasonable. So for example, if you're a surgeon and you're asking for the accommodation that you not come into work, that's not reasonable because there's no other way to do your job but be there. But in other jobs, there is quite a bit of reasonableness that can be done that would allow you to make an accommodation. Sometimes it can be modification of your physical work environment. If you're experiencing extreme fatigue because of your treatment, and you, for example, need a parking place that's a little closer, or you need to not have to stand up the entire time on your job when simply putting a stool in would be beneficial, that's a reasonable accommodation. Sometimes job restructuring, if that involves, you know, something like, I will work an extra hour if I can get a couple breaks during the day. If that's something that's going to work in the work environment that you're in, it's something that's possible, it's a reasonable accommodation. Now, occasionally it can be used for an extended period of leave time, like if you run out of the leave that you're entitled to. But usually it only works for extended leave if there's an end in sight to when you'll need your leave. So that does tend to work very well for a lot of people going through cancer treatment because it's often, I just need a couple more months or I need something like this. Could you protect my job until then? Doesn't mean you're paid during that time, but it means that there should be a job that you would come back to. Okay, in California, we have a broader version of the ADA, and it's called the Fair Employment and Housing Act. So it covers more employers if there's 5 or more. Now, sometimes there's employers that would be covered by the California law, but not the federal law. For example, state employees often aren't, you know, covered by the state law. Limitation on major life activity is a slightly different definition of than substantial limitation. But the major difference is, you know, even though now under the current state of the federal law we cover cancer in a lot of cases, in the California state law, cancer is specifically identified as a condition in which you might need these types of accommodations. Now, just some resources on that. It's kind of interesting how these resources work together. For example, if you make a complaint with the Department of Fair Employment and Housing, which is where you make state complaints, Sometimes if it fits under the federal complaint and they think it's actionable, they'll actually refer it over to the federal law. And so that would be the EEOC. The Equal Employment Opportunity Commission is the federal agency that helps with this. But for a lot of people, the first place that we refer them to is the Ask Jan website here, the Job Accommodation Network. That's a program that's been set up to help employers and employees come up with reasonable accommodations. They've done studies that on most types of accommodations, they cost employers well under $500. Now, the other side of what's a reasonable accommodation is employers can always come back and say something is an undue hardship. And so if it's something that's relatively cost neutral, they can't say that. But if it's something that's going to cost them thousands of dollars and they're a small employer, they can say that. Ask Jan, or the Job Accommodation Network, kind of exists to give people other ideas of what might be a way to deal with a situation, or they can point out what's the cost of some things, what are some other employers doing. So it's a very good resource when you're faced with a situation and you're wondering, what can I ask my employer? The other place, like I mentioned before, EEOC is the federal agency that does govern these things. And if you poke around on their website a bit, they have some specific guidances, and one of them is dealing with cancer in the workplace, and they give examples of what are some reasonable accommodations. For many jobs, it's just giving people extra breaks or allowing them to reduce their hours for a certain period of time. And then obviously you can always call us if you have specific questions about this. Okay, so in this case, with Jane, the ADA likely applies to her because of her employer. Even though she's part-time, she can still ask for a reasonable accommodation request. So if she needs to not work, for example, on the day she has treatment, and it's something that her employer can accommodate and is not going to leave them in the lurch, that's something that's perfectly reasonable to ask for. She can also strategize about her insurance options, whether that's trying to get into one of these high-risk pools, or because she's a relatively recent college graduate, she might still be under age 26. If her parents have group coverage, she might be able to get onto their policy. Okay, we're going to look at John, and we're going to talk a little bit about leave options. So John's a full-time bank manager, and he works at a bank that has 50 employees at his own branch. He's been on his job for 12 months, and he's recently gotten a diagnosis of cancer in which he realizes that he's going to need to take a few months off so that he can have surgery followed by chemotherapy. So what are his options? The big option that people should know about is the Family and Medical Leave Act, and that gives all employees who qualify under this law 12 weeks of job and health benefit protected leave. And so that leave is given to them so that they can take care of themselves, or in certain situations for a family member, if they are what's considered a covered family member. So of course we're going to need to go through some definitions again because it's legal and that's how lawyers like to write things. A covered individual is going to be either yourself, or if you're talking about your own family members, it's parents, minor children, so children under age 18, and spouses. This does leave some people in kind of a tough situation. For example, if you are a 26, maybe a 27-year-old, and you don't have any children, your parents can't take care of you because you're not a minor, and if you're unmarried, you don't have a spouse. So there have been, and in some states, they have extended who is covered through their state laws, and there have been attempts to do that in California, but as of now, that hasn't happened yet. And then the 12 weeks, they can be taken intermittently or all at once. This is something that matters a lot for people who are going through treatment. You know, sometimes when people do go through chemotherapy treatment, they know that there's, you know, say 2 days after they have the chemotherapy, they're going to be feeling really unwell, but after that, they're actually feeling okay and can go to work. So you can actually take your leave intermittently so that you are not just going for 12 weeks all at one time, but you're actually only going, you know, once a week or once a month, depending on when you need that, or a couple days here and a couple days there. And so that's actually what ends up working for a lot of people. Now, covered employers are all public employers, and that includes local, state, and federal. Some large private employers, so if you have 50 or more employees in a 75-mile radius, you are covered by this. There are some exceptions with certain religious employers where they are not covered by this, but for the most part, it's covering large employers. Now, the employees who are covered they have to have been there for at least 12 months. And they have to, although it doesn't have to be 12 concurrent months, it could have been like over the last 5 years they've worked there 12 months. And they have to have worked at least 1,250 hours in the last year, which works out to just a little bit more than 20 hours a week. So that's not even a full-time employee, but just somebody who has been working fairly regularly. Or it could be you worked, really intense hours if you have more seasonal work, like you help people file taxes. It was all in 3 months of the year. That's okay. Now, California does have a similar law, but in terms for people who are dealing with a cancer diagnosis, the only real difference in the law here is it also adds registered domestic partners who are considered spouses under the California Family Rights Act. The California Family Rights Act also adds a couple other protections for women who are pregnant or on maternity leave, but it's not so relevant to this situation. Okay, so if we go back to our friend John, there are 50 employees just at his own branch. Now, if there were only 25 employees at his branch, but say 30 miles away there was another 25, as long as it's within a 75-mile radius, that still works. So sometimes it can be a little difficult if you work for a place where there's more than one branch to figure out how many people actually are in a 75-mile radius. But you might need to talk to the HR manager and ask him how many employees there are. And he's been 12 months at his job, so he likely falls under the FMLA. Now, one thing about this and the other disability laws that I've talked about, these are just the minimums as set by the law. A lot of employee policies will also provide this type of leave, even if it's a smaller employee. Sometimes union contracts provide for additional leave. Sometimes just the contract that you signed applied for something else. So it may also be worth talking to an HR manager to figure out, or if you have your employee policy, to figure out what other types of leave you might have. Okay, we're going to go through and cover some issues on disability insurance, and we're just going to kind of issue spot what some of those issues are, and a lot of times we think of these as income replacement programs. So actually, before we go on to the federal programs and the state programs, the first one is private insurance plans. We do get a lot of questions about those. They're generally offered through people's employers, or people have sometimes purchased them on their own. The main thing about private insurance plans is they are governed by contract law, so pretty much what's in your contract is what you've got. And that includes how they define whether or not you're disabled. Sometimes you may feel that you can no longer work and you're not disabled, but there's some strange clause in that contract that indicates that maybe you're not. The other thing is a lot of times people don't understand how the insurance plan works, and they think it says, okay, they're going to pay 2/3 of your income, and they start looking at other things like state disability, and they think they can add them together. Very often, the private plans are offset against whatever you have coming in from any state or federal government plan. So it is worth it to see what's in that plan and if it's worth it to you, because sometimes if you're going to be eligible for other things, they're not really giving you a whole lot, although some other plans are actually really beneficial. The premiums on private insurance plans, though, do tend to be rather high as compared to something like life insurance because it is a self-selecting market. People who take private insurance tend to take it because they think they have a family history of something, they're worried about something. For the most part, even though it's probably something beneficial to most people don't take it. Okay, so let's go to our state disability. And California is actually one of only 5 states in the country that offers this. So in a lot of other states, you're out of luck for a while, unless you have private insurance. So here, for up to 1 year, you can get 55% of your wages covered through the state disability insurance plan. Now that may sound like a great deal, except you've probably been paying into it for as long as you were insured in the state of California. That's the little CASDI notation on your paycheck of what was pulled out of there. So you have to be unable to perform regular and customary work. You have to have a loss of wages, meaning if you had a lot of sick leave and a lot of vacation time banked and you didn't actually lose any of your wages, you don't qualify for it until you run out of that. You have to be unable to work at least 8 calendar days. So sometimes people will go on state disability insurance, even if it's something relatively short. You know, a horrible bout of the flu can knock you out for more than 8 calendar days. And then you have to file for that claim within 49 days of the date that you became disabled. Now, there are certain cases where, for example, if you were completely unconscious and that weren't possible, where you could actually extend that with good cause. But for the most part, you need to file that pretty quickly. And then you have to have earned at least $300 in the last year, which they took SDI taxes out of your paycheck. So occasionally there are employers that don't take SDI taxes out of your paycheck. For the most part, those are employers who have some other way of compensating you when you go on disability. And that's usually people like teachers, they pay into this PERS system. There's other people that are paying into other systems. But occasionally it's employers who are just not doing it correctly, and then people run into real trouble and probably need to call for some legal assistance. The other thing that I was not even aware existed in this state until I started here is that there is in California a family temporary disability insurance, and this allows people to take time off work and get up to 6 weeks of leave to take care of somebody, similar to that component of the Family Medical Leave Act. So it has the same requirements as our state disability insurance, and in fact it's run by the same program that runs our state disability insurance. So if you need to take off time to take care of a seriously ill child, spouse, parent, or your domestic partner, you are able to do that by applying for family temporary disability insurance. Now, if things become a little more than temporary, that moves us into the world of federal disability insurance. Federal disability insurance is all run by the Social Security Administration, and there are 2 types. They tend to refer to the first kind as disability, SSDI, and that's for people who do have a work history that fits within their requirements. And then there's also SSI, which is supplemental security income. That's for people who have never been able to work or who just don't have sufficient work history. The SSI also sometimes help low-income seniors who are over age 65 supplement their income if they aren't really pulling much out of Social Security. Okay, so the similarity between the 2 programs is how they define disabled. And that means that you can't do any substantial gainful activity. So in other words, you can't work, and what they mean by you can't work is you can't work so that you're earning more than $1,010 a month. So if you're doing just very, very limited part-time work for somebody, you might still qualify. Now, the reason that you're not working has to be due to a physical or mental impairment that is expected to last at least a year or is expected to result in death. So generally, people can't apply for this until it becomes evident that their disability is such that it's going to be more or less a permanent situation, or they are gravely ill. Now, because it does take such a long time for these applications to be filed and approved, there is a certain program called the Compassionate Allowances Program. So people who do get seriously ill, and most forms of cancer where the cancer has metastasized or it has become inoperable, those are the things that are on the compassionate allowance list. So if you do know somebody who has a condition like that and they need serious income assistance, you go to ssa.gov, see what the compassionate allowances list is, and those applications are fast-tracked. Okay, so the first program is based, like I said, on your prior work history, whether you paid into Social Security and your inability to continue working. Now, because it's based on your prior work history, it is on a sliding scale how much money you get. So if you were, earning just, $100 a week or something, your check is going to be significantly lower than if you were earning a few $1,000s a week. In order to collect SSDI, the kind of general rule is for people over 31, you have to have worked 5 out of the last 10 years. For people under 31, there's a bit more of a sliding scale of how much you had to work in that time. But it does, for most adults, it does have to be 5 out of the last 10 years. So if you stopped working 15 years ago, even if you worked really hard your whole life and thought you banked a lot of money, you can't get it through SSDI. You might be able to get it through Social Security later, but you won't get it through SSDI because they consider you not a worker, so you should apply for SSI. Okay, the SSDI program has some funky rules, particularly around when you can get it and when you're going to get paid. So basically, once you have been determined disabled, you can't get payments from the SSDI program for at least 6 months. Now, it might take longer for that for you to even be approved, and in which case they'll have to give you some retroactive payments. Like, for example, if I realize that I'm going to be more or less permanently disabled due to a condition that started, you know, back in, well, we'll go through an example in a second. So basically, you can get retroactive payments. And the other thing is, after you've been on the SSDI program for a while, 2 years, you can then start to get Medicare if you're under age 65. People always ask, what do you do in those other 2 years? That's when you have to go back to some of those other plans. It might be COBRA, it might be a HIPAA plan, it might be a high risk pool, or if your income is low enough, you might qualify for Medicaid. Okay, so let's go through the example. So let's say your disability began on the 1st of May in 2010. You applied for SSDI on January 1st in 2011. So it might take them until June of 2011 to give you an SSDI check, but you'll get a payment for 8 months. They're going to exclude a 6-month period from January to June, or you could start it from May to whenever, 6 months after that is, and then they'll give you a check for the remaining time. Now, SSI is a little simpler, but SSI is a federal entitlement program for people who have extremely low assets and income, and they don't have a work history or sufficient work history. People who get SSI in California, they're automatically eligible for our Medicaid program, but because it can take so long to get qualified for SSI, we usually advise people to apply for both at the same time. SSI applications often take up to 18 months to get approved. With both SSI and SSDI, particularly as the economy's gotten a bit rougher, there have been a lot more applications because there have been a lot of programs helping people to apply. And so only about 37% are actually granted at the first application. Now, what we often hear from people is, I've applied several times. And what I generally advise people is, don't apply several times, apply once and then appeal. There are several levels of appeal in the SSI and SSDI program. Usually you ask for reconsideration when you get your negative answer. Nothing usually happens then. But then there's another round where you can go to an administrative law judge and ask for an appeal with that judge. And over 57% of those denials are overturned when they go to the administrative law judges. After that, you can then ask for another form of review and eventually get to federal court. But for most people who apply for these disability programs, it's at that level of a hearing where they actually get the benefit. So it can take an incredibly long amount of time, and it can actually be very burdensome for the people who are waiting to get some cash assistance when they are too sick to work. So, well, with that, I'd like to go to some of the questions. I did see some people writing, and be happy to answer those. That was really just kind of an overview, so I'm sure there are questions. I'll start with a couple. Yes. Try to get through as many as we can. Okay, the first question is, please address going from an employer health plan to Medicare and supplemental plans regarding pre-existing conditions and coverage of very expensive cancer drugs. It's a very complicated question. So the first thing, going to a Medicare or supplemental plan regarding pre-existing conditions. Medicare and Medicare plans are not supposed to do any sort of underwriting regarding pre-existing conditions. But the second part of that question regarding the very expensive cancer drugs, as most people have heard, when Medicare Part D was passed, it's been very complicated. And it will actually take investigating all the various different Part D plans that are available to see if there is one that covers the cancer drugs that you need. It's definitely not a perfect system, and particularly newer drugs often don't make it onto any formularies, but it is the system that we have. Okay. Let's see, this question is from somebody who was laid off almost 2 years ago. Before that, they were going to have a knee surgery and called their HR department for disability, sick leave, etc., prior to the layoff. Then a month later, they were laid off. Is there any recourse for me? So prior to the layoff, you are entitled to any disability or sick leave that you were entitled to. One of the questions that we get a lot of times, though, is about when you take leave, does that mean that you are protected from being laid off? As long as it is not something that you can show that was targeted at you, you know, if you were the only person that was laid off and then they hired somebody for your position, that's not a real layoff. That means that you were targeted. And if that happened, then you should file a complaint with the Department of Fair Housing and Employment, or you can file with the EEOC. Now, if you happen to be on sick leave or on disability and the employer did kind of widespread layoffs, or they laid off even your position and never refilled it, then you actually don't really have a recourse there. So it does depend whether it was a genuine layoff or whether it was a layoff that is targeted at somebody because they don't really want to pay for you to be on sick leave or disability. Let's see. Where do you apply for FTDI? Does it run in addition to FMLA or does it run concurrently with FMLA? So with FTDI, family, like the family leave where you're getting paid by the state to go on, those two things need to run concurrently. And actually, the problem that we've seen with some people is that they are qualified to take paid leave through the state and get that payment, but they don't work at a place that's large enough to give them the protection under FMLA. So just because you're entitled to take paid leave doesn't mean they have to hold your job. So those are two things to keep into consideration. If you work at an employer where there are less than 75 employees, before you take the paid leave that you're entitled to through the state, you'll need to talk to your employer about whether they are really going to hold your job. But in general, they do run concurrently together. And a related question, sometimes people ask if you have to take your sick leave or your vacation concurrently with your FMLA, or if you take it before or after. It is up to the employer, but they have to set the same policy for everybody. Most employers require that people take their banked time at the same time they're taking that leave, but it can't be that they just make you do it and don't make anybody else do it. Now, most people want to get paid while they're on that leave, but some people realize that they're facing a very long absence, so they would like to string that out as long as possible. But it's up to what the employer's policy is on that one. More? Okay.
Jen, he's going to ask this question.
Yeah.
I just have a question. I was diagnosed with cancer in 2002, leukemia, and I did bone marrow transplant in 2003, and in 2004 I started work again, and I did my CDL, commercial driver license, started to drive like a truck driver, buy my own truck, everything gets fine, and after a couple of years, my health started to change. I have a GVHD, especially with my eyes, lips, my teeth, and on the end starts with my lungs. I'm short of breathing, and from year to year, it gets worse and worse. And there is a time maybe that I have to stop to work because I can do this job no more. And I'm a self-employed. And I just came here to see what's my option, you know, because I know how works this for self-employees, you know, because I don't be able to work no more.
Yeah.
Soon, you know, because I'm telling you the truth, you know, I don't want to die like a dog in a truck, you know. I try to do everything, you know. There is maybe a day when I have to stop to work, and that's coming soon, you know. And especially right now, they put me again on chemotherapy, and still it's not helping. You know, my health is getting from day to day more and more worse, you know.
Yeah.
And that's why I have to see what's my option to maybe change something, you know.
Yeah. Now, I mean, unfortunately, your options in the state of California and in this country are, at the point that you can no longer work, you should first apply for temporary disability because you can get that relatively immediately. As soon as it becomes apparent that that's not going to be sufficient, you would apply for the federal long-term disability. Now, as you saw on the slides, it can be very limited. The temporary disability is only 55% of what you were making before, which for most people is very difficult to live off of. One of the points about the temporary disability is they can't take any taxes out of that. So for some people, that does help quite a bit. But then after that point, it is, only the federal disability. Yeah? To the self-employed. Now, that would depend if you were paying into the SDI program as somebody who is self-employed. Otherwise, you would just need to apply directly to the federal program. It will take some time, but the federal program applies to everybody. I have a few more here. Okay. One of the questions is, what if your doctor doesn't want to put you on permanent disability? What are your options? Well, your first option would be to get a second opinion. A lot of times different doctors have different views of things, and we even hear from people sometimes, unfortunately, where it's just their doctor doesn't want to fill out the paperwork, which is really disheartening. But otherwise, it may be a difference of opinion between you and your doctor in what the doctor thinks that you are able to do. So sometimes it does just have to be a frank conversation with your doctor about what you are able to do during the day, what you are no longer able to do, what your job requires. Sometimes the doctor doesn't really understand whether it's a job where you're on your feet all day, or if it's a job that requires you to be, operating machinery or something that might be dangerous in the condition that you're in. But other than that, absent finding another doctor who does agree with your assessment of yourself, there's not really, anything that you can force the doctor to do. Okay. One of these questions I think is about discrimination on returning to work after treatment. One of the things about the ADA and why it is important on who it protects is another segment of the ADA is that employers are not allowed to ask you about your health condition when you're applying for a job. Sometimes we hear from people who have had cancer in the past and they're afraid it's going to recur again, so they feel like they're obligated to tell their employer or a potential employer that they've had cancer just in case it comes back. I mean, if you think about this, you're being a little hard on yourself because any one of us in this room could have an occurrence or a reoccurrence of cancer at any time. Similarly, any of us could have an accident, we could have anything happen to us. Like, you don't know what is going to happen in life, so you shouldn't feel like you need to tell the employer something that might give the employer opportunity to discriminate against you if it's not required. Now, a large number of employers won't discriminate against you, but if you think about it in the application and the interview process, they really know very little bit about you. So rather than having to give them the benefit of the doubt, it's usually best to not say that. Now, there are certain situations where they can ask about medical information, but they can't do that until they've offered you the job. So they can offer you the job, and then they can ask you to take some sort of medical exam, but only if they ask every other employee in that position to take a medical exam. And even then, even if it just reveals a history of cancer, but nothing about your current medical condition indicates that you can't do the job that you've applied for, they're not allowed to use that information to discriminate against you. Now, if you're in a situation where, for example, you've had chemotherapy and you've lost your hair, or something that might be a more obvious marker about cancer, and you think the employer might be curious, the employer is allowed to ask if you're able to do the job. If it's a job that has any physical requirements, they can ask that. But they can't ask you about cancer. They can't ask you more questions about that. Now, does that mean that all employers follow the rules and follow the law? No. But if you feel like somebody was discriminating against you because they somehow knew something about cancer or assumed that you had had cancer, you are allowed to file those complaints with the Department of Fair Employment and Housing as well, or with the EEOC. Okay. Here it says, in the state of Hawaii, if an employer allows 3 months to complete treatment and return to an occupation, and then treatment is recessed to last a little over 6 months, would it be considered an unjust accommodation to ask an employer to rehire the individual after a 6-month time period? Now, this is kind of a gray area of the law that we are in. So clearly, if it's an employer that's covered by FMLA, you get that initial 3 months. And then there's an area where you fall into what the ADA covers, a reasonable accommodation for additional leave. Now, is 3 months going to be reasonable to allow them to give you an additional leave? The employer might say no, that's something you could file a complaint on, but some of it's going to depend on the size of the employer, whether it is a reasonable accommodation or not, but it's definitely something worth asking. And when you're asking for that, it's also worth asking, worth informing the employer that this is something that has an end in sight. Now, it does sound like a long time to be on leave, but if you think about it, the employer is not required to pay you during that time. They're just required to hold your job. So yeah, it is something worth doing, but it's not one of those things that's a complete black or white, yes, you're going to get this, or no, you're not. If you do feel like they're discriminating against you personally, you've seen them give this kind of leave to other people, they have a policy that indicates they might, then it would be worth something filing a complaint to either the state agency in Hawaii that would cover this or to the EEOC. Let's see. Okay, from the time a person is diagnosed with cancer, how long does a pre-existing category last? Currently, from the time that a person is diagnosed with cancer, how long does a pre-existing category last? There's a couple complications into this question. Now, if you're covered by HIPAA, there's only so long that they can look back into your medical records, but it's not from the time you're diagnosed, it's from the time when your treatment ended and you were shown cancer-free. So typically there's an 18-month look-back period or a 6-month, depending on what area of law that you're under. But otherwise, if there's any indication that it has not been completely eradicated, that pre-existing condition generally goes with you for quite a long time. Now, with the HIPAA protections, if you've been covered all through your treatment and you change insurance company, they can't consider that a pre-existing condition because that's a condition that you've been covered for. As long as you've had coverage for, up to a year, depending on how those insurances line up. Now, if you're on the individual market and you're just buying insurance on your own, they typically look through anything they can find in your insurance or in your medical history and use that. They might not find the cancer, but they might look at something else. I've seen things, as small as being on an antidepressant or having, a slightly negative test that never amounted to anything. So the individual market is quite different, but in HIPAA there is, it depends on whether the pre-existing condition was covered or not. If it was covered, you're pretty much in the green. Okay. Can a spouse add their spouse to their health insurance even though there is a pre-existing condition? This is something that's going to depend how you got your insurance. If you're getting your insurance through a group coverage, you can generally add your spouse on even if your spouse has a pre-existing condition, but your employer might have certain times of the year when you're allowed to do that. Like they might have their annual renewal time, and otherwise you usually have to have a major life event like you just got married or something like that. But as long as it's the right time, you can add them on. Now, if it's an individual policy that you bought on your own on the individual market, then in order to add your spouse, they get to ask about your spouse's medical history as well and then quote you the rate that they're willing to quote you. So oftentimes that does preclude the spouse, and then the spouse needs to go into one of the high-risk pools or something like that. Okay. Let's see, after finishing with long-term disability, can my job let me go? I'm not sure if that means, well, that could mean a couple different things. After you finish the time that you're on leave, can they let you go? Yes, in most cases, because we do have at-will employment here in California. So unless there is something in your contract that allows you to, stay on. But if it's just a matter of you took FMLA leave and then you want to come back, the only reason they could let you go in that case, as long as you're coming back within the period of time that's covered by that, as long as they, in that case, as long as they don't have a reason to let you go, they're not allowed to let you go. So the only reasons they can let you go is if there's an actual for cause, like while you were gone, they looked through your files and found out you were stealing from the company, then they can let you go, because that's an actual reason or a permissible reason. if they do layoffs to everybody, they can. But if it's just, I took 2 months of FMLA leave and I would like to come back to work now because I'm done with my treatment, and your employer says, no thanks, we're letting you go, that is exactly what is not permitted by the law. Let's see. Oh no, I read the clock wrong. I'm like, thought I went way over. Okay, how do they determine if you qualify for FMLA? The first part of the question, FMLA is a strict, if you fit within the statute, you qualify. If you're asking how they determine if your sickness is severe enough, that is something that your doctor would write a medical certification letter for. Now, if you've had medical certifications in the context of getting temporary disability or something like that, what the doctor needs to do for FMLA is actually really limited. They only need to say when your condition started, when you're expected, or how much time you expect to need off, and that it is something that's severe enough that you cannot work. They don't actually need to say what your diagnosis is. So some people who don't want their employers to know that they're going through cancer treatment because they don't, really want to be perceived as someone having cancer, or they're not sure if their employer would discriminate against them. Those people don't have to have their doctor say exactly what the condition is. Now, interestingly, some of these forms, sometimes that employers use, they do ask people to write their diagnosis, but under the law, the doctor's not required to put that in there. So it would be worth talking to your doctor if you're somebody that doesn't want to reveal that to your employer about what they're going to put in there. If it's something that your doctor insists that they need to put it in there, and you need, you want to be able to cite the law or give your doctor something to prove that, feel free to give us a call and we'll help give you some materials to show your doctor that no, they don't actually need to say what you have. One thing on that is oftentimes, if you're getting your medical certification done by, say, an oncologist, that generally does tip off what the diagnosis is. So sometimes people like to have their medical certification done by their primary care provider. Most primary care providers will do it, but sometimes there's even a little pushback from the primary care provider because they'll say, well, I don't really know what your treatment is with a specialist. I don't know what's going on. So that can also be an area where you might need to have your primary care provider in contact with your oncologist so that they can coordinate that. And there again, if you need a little help explaining to the primary care provider why you might be asking them to do it rather than the oncologist, we'd be happy to give you some materials on that so that they can write that medical certification. But for anything that's going to your employer, unless you are declaring that it's your employer that caused your problem, or you're trying to get disability payments from your employer, you don't need to tell your employer what your medical condition is. And that counts also, too, for reasonable accommodations through the ADA. You don't need to give them all the details of your treatment and diagnosis. You just need your doctor to say what the accommodation is that you need, how long you'll probably need it for, and then, your employer, if they want to, have a doctor write something again in a couple months, they can, but they aren't entitled to your personal private information. And then there's another question here, do I have to take my sick leave and vacation first? I did mention that briefly, that is something that is left open in the law up to employer policy. So some employers do have that requirement, and they are permitted to have that requirement. Let's see. If you own a house, will SSI put a lien on your home? SSI doesn't work quite the same as Medicaid does. Medicaid can, after, if you qualify for it later in life, they can do that. But typically, that's not how it works with SSI, although owning a house can make it difficult to qualify for SSI. Okay. When dealing with insurance options with an employer that is based in another state, do state options, California, or federal options have a higher priority? This is a complicated and very good question. So it depends. Now, typically, all insurance companies are at some point governed by federal law, because there is a law that's referred to usually as ERISA that covers anything that's given to you by your employer. So they are at least covered by ERISA. Now, some states have additional protections. In California, we have quite a lot of consumer protections, but it only is used for those that are licensed by the state of California. So typically, if you're getting your insurance and it says, for example, Illinois Blue Cross, then your insurance has not been licensed by the state of California, so you have federal options available, or you may have options available in the state in which that insurance plan was licensed. This usually only happens to people when they are working at rather large employers, because some of those are actually pooling their own money, and it's just, even though it looks like an insurance company, they're really just administering the insurance for the employer. But in general, it's the state where the insurance plan was licensed that governs what the insurance plan can do. And I think, you know, as there's a bit of disparity in what the states require of insurance companies, you will see a bit of people trying to buy cheaper insurance from other states. But, you know, so it is a complication to our already a complicated insurance world. Okay, when you work in an industry that is on-again and off-again work, and you're basically like an independent contractor, but not, so we're hired and put on jobs through union, are we covered by the law regarding protection of a job that we're able to do while recovering, and if so, how do we approach? That can be very complicated depending on what your paycheck is actually saying. Now, if you're working for an employer that's placing you somewhere and you're always getting the same type of paycheck from the same person, then all of the law that I had just mentioned, as long as, you know, for FMLA, as long as you've been there 12 months, you know, or for certain other job protections, it depends how long you've been there. Now, if you are actually just working for somebody short time and then not working and then working for somebody else short time, then you might not in certain situations be able to get some of the protections that require you to work for somebody for a long period of time. But other protections, such as I worked for somebody for a short period of time, they offered me health insurance, and then I stopped working, you would be entitled to get COBRA because that doesn't have a limit on how long you need to work before that protection comes in. So it really just matters how long you've worked for the employer and then what the corresponding law says about how long you need to work there. But it can be complicated when you're working for several different people unless you're always getting your paycheck from the same actual employer. Only if the union contract requires them to, and often union contracts do. But in general, is there a general other state or federal law that makes them responsible? No. So, although most people in unions, their union contract usually offers some additional protections that you don't otherwise have. So, okay, diagnosed a year and a half ago, but work and income was affected prior to diagnosis. What year do they base the disability on? They base it depends on which disability. State disability, it's usually the most recent year. For the SSA, it's more of a composite of what you put in over time. What's that question? Any other questions? Yes.
And I'm returned back to work full-time. I can work, but sometimes because of the medication, you're having to go to the restroom more, or you're thirsty. And my manager came up to me and told me, do you have a health problem? And I'm like, you only know I just got back from, you know, being off for a year. And so he made me feel real uncomfortable. So I had my medical doctor write me a note saying I go to the restroom, and I happened to mention that to one of the supervisors.
Wait, what did your medical doctor write you again?
He wrote me a note, and I haven't turned it in because I just got it in the mail the other day saying that due to my medications, I have to go to the restroom more often.
Okay.
And so I haven't turned it in because I wanted to come here, but my immediate manager made me feel very uncomfortable. And I happened to tell the supervisor, who I'm very good friends with, and she went to a manager, and the manager said that, no, I didn't need it, but I still just don't feel comfortable. Or sometimes when I tell them I need certain days off because I have to come over here to see, you know, sometimes you have 2 or 3 times a month to see, you know, your doctors. What are my rights as a cancer survivor patient?
Yeah, okay. So it sounds like what you need is something that would be a reasonable accommodation. And so along the lines of what is required under that law, what you've asked for from your doctor is exactly right. The doctor only needs to say what you need. They don't need to say why you need it. Now, in terms of dealing with, your supervisor versus somebody else in the company, some companies, what they do is they make one person responsible for any accommodation requests. That's often the HR person. And the rationale behind that is that way if there is anything that's revealed in the medical certification or anything like that, it's all held with that one person and it's not disseminated throughout the rest of the company. Because they're also not supposed to share any information about you that they get even when you're asking for an accommodation. So your manager who has been asking you that, to the extent that you have to tell them that you need a certain sort of accommodation, it also might be worth reminding that person that they do need to protect your medical privacy. That is a requirement of employers that they can't share your medical information with anybody else except for people who need to know as your supervisors. So they can't go telling your other coworkers or anything like that, unless there's something that they need to know, like somebody needs to cover for you while you are, on a break or something like that, but they don't need to know why they need to cover for you. So, there are some protections you have about what they can say and what they can say to other people, but there's not protections in terms of, are they treating you necessarily with the most respect that you would like. Unfortunately, some supervisors are just going to be much more understanding and accommodating, whereas other ones just aren't very nice people. So, yes. Can they terminate her if she requests too many days off during the month? Now, if you anticipate that you're going to need to request a certain amount of days off during the month, you should do it in the sense that you are making a reasonable accommodation so that you are protected. In that case, the employer can come back and say, this is an undue hardship, we can't give her that many days off, and they essentially need to be able to prove that it's an undue hardship. Now, if it's a large company and lots of people can cover, they're probably not going to be able to prove it. If it's something where they really aren't covering the amount of work that needs to be done, they may be able to prove it. So it really is a case-by-case situation, and it also depends on whether they can bring in other people temporarily, if there are other things that can be done. But in a situation like that, you would want to be clear that you're asking for a reasonable accommodation as somebody who's protected and not just, I just don't show up. Yep.
One final question.
I think you were in the context of SSDI or SSI, and you said California is only one of 5 states that what? I missed
that. Has SDI. That would be a temporary disability payment.
What were the other 4 states?
Let's see, New Jersey, New York, Rhode Island, and I believe Hawaii. And then Puerto Rico also does. Not a state, but they also do. Yes, one more.
The SSI or SSA, and they didn't really give me an option as far as wanting whether or not I wanted to apply for SSI at the same time.
Uh-huh.
They basically just put it in.
Yeah.
Now, when you're on SSI, that keeps you from receiving other program monies.
Not entirely. You can only receive up to a certain amount on SSI. It's around $1,000. So if you're getting some from SSDI, they'll reduce what you get from SSI. Or if you're getting some from private disability insurance. So you can apply for them concurrently if you don't have a lot of work history. Yep. Yeah. Yes, although SSI shouldn't be less than what your food stamps would be, but maybe if you have some other programs in there in your SSI payment. Okay, yeah, if you have other things in there, you can opt to not take SSI. There's no requirement that you take that in the food stamps program. So, yeah. Yeah, so if your SSI payment is not very much, it might not be in your best interest to take it. Does that affect your Medicare? SSI might affect your Medi-Cal if you're getting it through there, but SSI and Medicare aren't linked at all. So if it was your SSI that was making you eligible for Medi-Cal, you would just need to show that you were eligible for it some other way, which is really the same determination.
Let's
Okay.
give our speaker a round of applause. She's
All right,
wonderful.
thank you.
We ask you please take a moment to fill out your evaluations before you leave. Thank you, Jen.